oh, these activist judges and how dare they, this is ridiculous. Hi, this is Jeff Marsacci, the Plain English Attorney, and you've probably seen somewhere around the internet, oh my gosh, Geico has to pay millions of dollars to this woman because she contracted an STD in the back of one of their insured cars. Okay, tell me what this really means. Because guaranteed out there right now in the media, there's all of this uproar about, oh, these activist judges and how dare they, this is ridiculous. Everybody, or just about everybody, probably has it wrong. So let's just walk through, and there's a very good article. It's in The Guardian. We're going to link it below. This is some good stuff. So, Insurers Geico ordered to pay woman who caught STD having sex in car $5.2 million. Missouri Appellate Court rules Geico must cover injuries and losses from disease after 2014 incident in Hyundai Genesis. All right. The insurance giant Geico must give more than $5 million to a woman who had sex with a motorist in his car and contracted a sexually transmitted disease, a Missouri appellate court ruled. The ruling represents a preliminary legal victory for the plaintiff over the company, best known for commercials starring an anthropomorphized gecko which speaks with a British accent. Okay, well, I kind of like the gecko. The big issue here is if you're just seeing this in the media, chances are they are just doing stuff to get you all riled up and angry and upset. And you may have even heard, oh, we got to get rid of these activist judges. Or oh, you might have even heard, oh, this is all Joe Biden's fault. Look, the president has absolutely nothing to do with this. The judges really don't have much to do with this, and I'm going to explain why. The other thing, if you're kind of pointing your finger at one political party or another, keep in mind these are Missouri appellate court level judges who are elected. So if you want to shout at the people of Missouri, okay, but the judges are right. So let's go into this a little more. Geico can still go to the state Supreme Court to seek a reprieve and may get a more favorable ruling in a related federal case. The plaintiff, identified in court records as M.O., alleged that in 2017, during sexual encounters in a 2014 Hyundai Genesis, her boyfriend infected her with the virus that causes genital warts. All right. You're probably seeing that and thinking, this is ridiculous. This isn't what car insurance is meant to cover. So how could this case possibly have happened the way it did? Well, we're going to see in a second, it wasn't that it went to court. It actually went to binding arbitration. Attorneys for Geico argued that they never had a meaningful chance to contest the claim. The appellate court found Geico did get the chance, an opportunity it forfeited when it chose to simply deny coverage. We would note that Geico had every opportunity to enter a defense, but chose not to do so, said the ruling, issued by judges Edward Ardini, Karen King Mitchell, and Thomas Chapman. Geico has no right to relitigate those issues. So what exactly does that mean? All right, and this is actually a very, very common thing that happens when you're fighting an insurance company, or even more, you're signing on to these contracts that mandate binding arbitration. Well, why do the companies do that? Because in general, arbitrators tend to go much more towards the companies, and it's because they're experienced. There's not a jury whose emotions are really being swayed. Arbitrators tend to be like retired judges or retired lawyers or active lawyers. And the arbitration is that they're kind of putting on the black robes, but not really of a judge, so that they can just get whatever information is out there for the case. We're not going to worry about, okay, filing deadlines, and okay, we will get this, and we're going to appeal this thing, and we got to pitch it to a whole jury. No. It's all being done in front of the arbitrator, and it's a lot less formal, which means it's a lot less expensive, especially for the company. And they end up getting rid of and getting thrown out a lot of cases that aren't favorable to the companies. So they always push this binding arbitration. The thought is, all right, you go in, you get a ruling, and that's it. It's binding. It's done. So what happened here? Well, Geico and Missouri have separate but related cases pending in federal court. But when we get over here to entering a defense, it looks like Geico just said, this is ridiculous. We don't need to put in a defense. We're just going to rely on you, to arbitrator. We're not going to put forth any evidence. Okay. The problem is the arbitrator looks at what's right in front of them. And if Geico really didn't put on any kind of defense, they lost their shot. It's the equivalent of, say you've got a man and a woman, they're going for a divorce, and one of them doesn't show up. And instead, the other person says, okay, look, here's everything that I'm saying, here's what I have, here's my proof and whatnot. And the judge rules completely in that spouse's favor who showed up. The other spouse doesn't get to say, but you never heard my side. Well, you didn't show up. You didn't present anything. That's what happened here. In this Missouri appellate court wasn't relitigating the issue. They weren't going through and saying, okay, this evidence presented, and okay, we're going to look through this, and we're going to make some decision based on... No, they are simply reviewing and seeing, was the binding arbitration done correctly? And it was. That's what they ruled, that the arbitration happened and it was proper. Geico had every opportunity to present their evidence, and they just said, no, we're not going to present anything, or at least not anything meaningful, according to this ruling by the judges. So that's really the whole crux of it. Missouri's alleged damages have no nexus to the ownership, maintenance, or covered use of the Hyundai Genesis, Geico's lawyers have argued in federal court filings. Her injuries arose from her failure to prevent transmission of sexually transmitted diseases by engaging in sex with someone carrying the virus causing genital warts. Yeah, but you didn't argue that in arbitration, did you? So now it becomes this whole big case, this whole media explosion, and if all you got was the very surface level, you're probably screaming at the Missouri activist judges. No, this is the case of the company completely failing to present its case to the arbitrator. They pushed for binding arbitration, as the companies almost always do, just because it's cheaper and very often goes in their favor. But this is one instance where it didn't work, and now they're saying, this binding arbitration thing isn't fair. It violates our due process. No. Due process means you had an opportunity to give your say, not that they came down on your side. They had the opportunity and they blew it. So that's what this case is really about. So before you get all upset at the, quote, activist judges and whatnot, just realize this was about a court affirming binding arbitration. Now, you can yell and scream at the arbitrator all you want, but don't think that this has anything to do with politics or judges or runaway jury verdicts and whatnot, because that's not what really happened. So I hope you found that information useful. I always request, please subscribe to the channel, like the page that you're on, follow us on all the different social media that we've got listed in the description. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.